Hello everyone, now we will start the new act, Dowry Prohibition Act. Section 1 talks about short title, extent and commencement. The act applies to the whole of India and it came into force on 1st July 1961. Now, section 2 talks about definition of dowry. Dowry includes any property or valuable security. Valuable security defines under section 2 subclause 59 of BNS. Basically, dowry means dahej. Dowry is given by one party of marriage to the other party of marriage. Either it will be given by either party of their parents or any other relatives also include in this, at or before or after marriage. But it excludes presents, gifts given by their parents to the bride or bridegroom at the time of marriage without any demand. Now, section 3 talks about penalty for giving or taking of dowry. Whoever gives or takes or abets the dowry shall be punishable with imprisonment which is not less than 5 years, and also he will be charged by fine which shall not be less than 15,000 rupees or amount of the value of dowry, whichever is more. Section 4 talks about penalty for demanding dowry. Whoever directly or indirectly demands dowry from the parents of the or relatives of the bridegroom or bride shall be punishable with imprisonment which shall not be less than for 6 months, or it will be extended to the 2 years, and also he shall to pay fine which may extend to the 10,000 rupees. Section 4A talks about ban on advertisement. It prohibits publishing any advertisement offering dowry. If anyone can do so, he shall be punishable with imprisonment for which is not less than for 6 months, but which may extend to 5 years, and he also shall pay to fine of rupees 15,000. Section 5 talks about agreement for dowry is legally invalid and void in nature. Section 6 talks about dowry to be for the benefit of the wife or her heirs. If dowry is received by any person other than the bride, then the dowry is transferred to her within 3 months of the marriage. If the woman dies before receiving it, then it will give to her heirs which are entitled to receive it. Heirs include her children's husband or parents. Failure to transfer dowry leads to penalties. Section 7 deals with cognizance of offences. It means who will take cognizance of the offences related to dowry. A judge can take cognizance suo motu. It means a judge can take cognizance upon its own knowledge, or upon a police report, or upon a complaint made by aggrieved person or her relatives, or recognized welfare institution or organization, or her parents. Cognizance was taken by judicial magistrate, first class or metropolitan magistrate. Section 8, 8A and 8B talks about procedural aspects and enforcement. Section 8 talks about offences to be cognizable, non-bailable and non-compoundable. Cognizable offences are those offences in which a police officer can arrest a person without a warrant, And a non-bailable offences are those offences in which bail cannot be granted as a right, and non-compoundable offences are more serious in nature, which cannot be settled out of the court. Section 8.8 talks about burden of proof. Any person who takes or abets the dowry, the burden of proof is upon him that he will not take any amount or any kind of dowry or presents by the bride or bridegroom. Section 8b talks about dowry prohibition officers. It empowers state government to appoint dowry prohibition officers to enforce the act, raise awareness and prevent offences. Section 9 and 10 talks about rule making power. Under Section 9, central government has power to make rules for the ensuring its effective implementation of the Act. Same with the Section 10. But in Section 10, state government has the power to do effective implementation of the Act. Thank you and stay tuned. Don't forget to subscribe my channel.